Another common type of misconduct occurs when the police use highly suggestive procedures to make an eyewitness identification of a suspect more likely, which in turn has the effect of contaminating an eyewitness's true recollection of the crime and the perpetrator. Yet another occurs when the police fabricate or plant evidence for the purpose of implicating a suspect in a crime. A related abuse of power occurs when the police use interrogation tactics that coerce innocent defendants into giving false confessions and encourage incentivized witnesses, such as jailhouse snitches, to give false testimony against an accused. Finally, in cases where forensic evidence exists and is relevant, investigators often resort to highly unreliable forensic disciplines, such as bite mark and microscopic hair comparison analysis, to implicate suspects. Meanwhile, prosecutors routinely rely on unreliable evidence procured through police misconduct to obtain convictions or force plea deals with defendants. Ironically, law enforcement misconduct is most often seen in cases in which there is a paucity of truly incriminating evidence, usually because the suspect in such cases is in fact innocent. Yet a strong belief by the police in their own ability to, quote, know what really happened, coupled with the effects of confirmation bias and a desire not to let the perpetrator beat the charge, lead investigators astray and result in abuses of power that send innocent people to prison. It's not that the police set out to frame someone they know to be innocent, although that sometimes happens, if rarely. More often, the police feel the need to create or find evidence necessary to convict where none exists. Those who work to correct injustices of this type have a name for it: noble cause corruption. Such abuses of power have resulted in the wrongful prosecutions of thousands of innocent people. Countless innocent people have likewise been imprisoned, and many have been sent to death row. Tragically, some of those sentenced to death were executed for crimes they likely did not commit. Racial minorities have disproportionately been the target and victims of police and prosecutor misconduct, particularly in the American South, where an enduring legacy of racial prejudice has long plagued the criminal justice system. Just in the past 30 years, due in part to advancing scientific technologies such as DNA testing, more than 2,800 innocent people serving prison sentences have been exonerated and freed from the shackles of confinement, their combined jail sentences adding up to more than 25,000 years of prison time. This number, however, represents only a small fraction of the number of persons wrongfully convicted over the same period, and it does not reflect those who were acquitted or granted a dismissal of the charges after being wrongfully arrested. You would think that all the actors in the court system would happily work to correct erroneous convictions, but this has not proven to be the case. Prosecutors and judges have shown remarkable hostility to overturning convictions based on new evidence or evidence of misconduct by police or prosecutors, even when the new evidence includes reliable scientific data such as DNA comparisons that exclude the defendant as the perpetrator of the crime. Attorneys representing defendants who are challenging a conviction face steep uphill battles in winning exonerations, with the rare success often taking years and even decades to bring about. For each of the exonerees, there remain innumerable others still sitting in prison, praying for their day of justice to come. It is better that 10 guilty persons escape than that one innocent suffer, so said the English jurist William Blackstone in the 1760s. In the name of law and order, however, police and prosecutors have turned this bedrock principle on its head. As a criminal defense and civil rights attorney for more than 40 years, I have spent my career fighting abuses of power in the criminal justice system whenever and wherever I found them. My work has been in America's courtrooms, where the state's mechanisms for the deprivation of liberty slowly grind, and where those responsible for wrongfully taking a person's liberty are all too rarely held to account. I have worked in the